Hi there. We at the Monash University Faculty of Law are extremely excited about the Legal Challenge, which is a new and innovative competition we have created especially for years 11 and 12 legal studies students. The concept behind the Legal Challenge is to inject a new and fresh dimension of excitement and interest in your legal studies. By participating in the Legal Challenge, you will find it will help you to improve your oral presentation skills and logical and analytical thinking. There will only be one winner from each school. That winner will compete against winners from other schools in a final to be held here on campus at Monash University. The competition centres on witness examination, and what you're about to see is a courtroom drama that illustrates techniques that are used in witness interrogation. At the conclusion of this film, my colleague, Professor Louis Waller, will take you through the deliberate mistakes that are made by counsel for both the prosecution and defence. And this is the essence of the competition. Winners will be judged on their ability to cross-examine an opponent's witness after that witness has given evidence in chief. The purpose of cross-examination is to obtain evidence favourable to the cross-examiner's client and to discredit. Professor Waller will this in more detail when he presents his analysis. The trial you're about to see is an example of the kind of problem your teacher will be presenting for your competition. I am sure you will enjoy it, and I encourage each and every one of you to participate. Obviously, all this would not happen without the cooperation of your school and especially your legal studies teacher. On behalf of the Monash Law Faculty, I sincerely thank them and I wish you every success. Finally, I hope you continue with your legal studies and pursue formal legal training with us here at Monash University. Good luck, everyone.
The Faculty of Law at Monash University has much pleasure in presenting the Legal Challenge.
Silence, all stand please, remain standing. All persons having business before this honourable court are commanded to give their attendance and they shall be heard. God save the Queen. Be seated, please.
The Queen against Martin.
I'll take appearances.
Your Honour, I appear as counsel for the prosecution.
I appear on behalf of the defendant.
I can't hear you.
I appear on behalf of the defendant.
You don't understand. I can't hear you.
I appear
if you are not standing up.
I apologise, Your Honour.
What?
I apologise, Your Honour.
Good. Let's get on with it.
Your Honour, the defendant, Miss Joanne Martin, is charged under Section 18 of the Crimes Act with intentionally or recklessly causing injury to another person without lawful excuse.
Look, I know Section 18 of the Crimes Act better than I know my wife. What I want are the facts of your case.
Yes, Your Honour. The prosecution will prove that on the night of the 19th of January 1998, Miss Joanne Martin shot the victim, Mr. Alan Nilsson, in the leg. The prosecution will call Mr. Nilsson as a witness. He will give evidence that on the said night he was walking home by himself. He will state that he entered the front garden of Miss Martin's home for the purpose of relieving himself. As he was doing so, he was interrupted by Miss Martin, who then shot him in the leg. He will give evidence that the attack was unprovoked and unlawful.
Any danger we could hear from Mr. Nielsen on the subject?
Yes, Your Honour. I call Mr. Alan Nilsson.
Mr. Alan Nilsson. Silence. What is your full name?
Alan Nielsen.
Raise the Bible in your right hand, your other right hand. Do you swear by Almighty God that the evidence you shall give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God?
No problem.
What is your name and address?
Alan Nielsen, I live at 34 Everleigh Street, Glen Waverley.
Correct. Please state your occupation.
I'm a computer salesman. I've been working about 4 months, more of my time spent with training than actually selling.
Do you recall the events of the evening of the 19th of January 1998?
How could I not? That's the time that lunatic woman shot me.
Objection, Your Honour.
Objection. I've seen a bit of LA law, have we? Counsel, please control your witness.
Control yourself, Mr. Nielsen.
Control yourself, Alan.
Please tell the court what you did that evening.
I went to a seminar until about 9:30, then I went with the boys to the pub.
And
I
what
went
did you...
with my friends to the local hotel.
And what did you do there?
Well, what do you reckon? Got drunk, naturally. Played some pool.
When did you leave?
Objection, Your Honour. Leading question. The question assumes Mr. Nielsen left the hotel.
Is that Mr. Nielsen in the witness box?
Yes.
Then we can safely assume he left the hotel at some stage, can't we?
I guess so.
You guess right. Get on with it.
What time did you leave?
1:30 a.m. when the pub shut.
And what did you do then?
I decided to walk home. I don't live that far away.
What happened on your way home?
Well, because I'd had that many beers, I remember thinking I need to leak something chronic.
I have an overwhelming urge to urinate.
Oh, well, you know what it's like.
So what did you decide to do?
Get off light ale.
So how did you solve this little problem of
Speak for yourself, darling.
Mr. Nielsen.
Yeah, decided no time like the present, mistake number one.
Which house did you stop at?
Fruit Loops joint.
What would the postman call it?
87 Doris Street, Glen Waverley.
What happened there?
I relieved myself in the bushes, and then the light comes on, and there's the well-known contravener of Section 18 of the Crimes Act standing in the doorway of the house holding a gun. Next thing I know, I've been shot. Woman's crazy.
Oh, objection, Your Honour.
Counsel, this is your last warning. Control that witness of yours.
Did you know Miss Martin before the incident?
Who didn't? It's pretty hard for the resident town lunatic to stay unnoticed.
Objection, Your Honour.
Sustained. Control yourself, Mr. Nielsen.
The prosecution has no further questions.
Defence counsel.
Yes, Your Honour. Mr. Nielsen, you were drunk that night, weren't you?
What, so I'm the one on trial here, am I?
You were drunk, weren't you?
Yeah, big deal. I wasn't driving.
So drunk, in fact, that you were wearing a pair of black underpants on your head, weren't you?
Hey, I wouldn't be handing out fashion advice if I was dressed like you. Underpants, I mean, that's a lot of crap.
Do not use that language in this courtroom, Mr. Nielsen.
I'm sorry, Your Honour. It was a baseball cap I was given at the convention. Baseball cap's an item of fashion with which you're no doubt unfamiliar, it being an invention, of course, of the 20th century.
Do we have this fashion item here?
Yes, Your Honour. Exhibit A. Can you show us how you were wearing the cap that night?
Like this. Because it's cool, man.
Thank you. You were staggering around the defendant's garden, muttering to yourself, weren't you?
Guilty of being in the garden, not guilty to staggering.
Like drunks can tell if they are walking in a straight line.
Objection, Your Honour.
Sustained. Counsel will refrain from commenting on the witness's evidence and vice versa.
Yes, Your Honour. Now, when the light on the porch came on, you decided to expose yourself to the defendant, didn't you?
I was doing it my pants as I was turning around.
Did you move at all from your position by the shrubbery?
No, I never moved from my spot.
You didn't lunge towards the defendant at all?
No, I did not.
So there was no other move other than you turning?
No.
So you would have the court believe that you were able to execute a perfect turn in your drunken state?
I turned, but there's no way I lunged at her.
You were leering at the defendant, weren't you?
I'm not that kind of guy.
Can you give us a description of the defendant's appearance as she was standing on the porch that night?
She was wearing a big dressing gown which was undone, enabling me to see her nightie underneath. The presence there of her two breasts indicated to me that she was a female person.
Would you say that she appeared to be a voluptuous woman?
I don't know what you mean.
You noticed she was curvaceous.
Yeah.
In fact, you focused on her curves, didn't you?
My eyes and her breasts were both present that evening. It was inevitable they would meet.
Which caused you to shout, "My God, you've got big ones."
No, I said, "My God, you've got a gun."
If I could take you back to your description of the defendant, you didn't mention anything about a gun. You focused on her curves. Surely you don't expect the court to believe that you yelled, "My God, you've got a gun," instead of, "My God, you've got big ones."
Listen carefully, read my lips. I said, "My God, you've got a gun."
You lunged at her, didn't you?
Not having a good day, are we? I didn't lunge at her. I was throwing up my arms. I was surrendering, for God's sake.
You did move towards her then.
Inasmuch as there was forward motion in my arms whilst attempting to surrender, yes, maybe I did move towards her, but only a little.
I give up.
I was trying to.
The witness may step down. Open your case, counsel.
Yes, Your Honour. The defendant did not intentionally or recklessly cause injury to Mr. Nielsen without lawful excuse. The defence will establish that on the night of the 19th of January 1998, the defendant was woken up by loud noises outside her house. The defendant will testify that...
Counsel, we do not testify in Australia. Let's get your Australian content up.
The defendant will give evidence that she went outside and was confronted by a man exposing himself. She will also give evidence that she fired a warning shot when he lunged at her. I now call Joanne Martin.
Joanne Martin. Silence. What is your full name?
Joanne Martin.
Raise the Bible in your right hand. Do you swear by Almighty God that the evidence you shall give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name and address.
Hi, my name is Joanne Martin and I live at 87 Doris Street, Glen Waverley.
And what were you doing on the night of the 19th of January this year?
You mean before shooting Super Perv?
If you wouldn't mind.
Okay. After target practice, I came home, fed my two Persian cats and went to bed. And this was about 9:30 p.m. How's that?
Copybook.
What happened then?
Well, I'm a light sleeper, and at 2:30 a.m. I heard some loud rustling noises, and this woke me up. I also heard a voice.
How did you react?
I live by myself, and because of reports of a rapist in the area, I was very scared.
What reports were these?
Objection, Your Honour. Hearsay. The defence is clearly referring to written documents which have not been tendered into evidence.
Overruled. The witness is not seeking to establish that there was a rapist in the area, but only that she believed there might be and was afraid.
So I got out of bed and went and got my rifle. Then I walked to the front door. Then I turned on the porch light and then I opened the front door.
And what happened then?
Well, the first thing I saw was someone exposing themselves. It was an indecent sight.
Can you describe this man?
I wasn't sure it was a man.
Hey, fair go.
He was wearing pants, a t-shirt, and he had a pair of black underpants on his head.
How were you able to tell?
I have 420 vision. Besides, the porch light was on.
What happened then?
Well, he screams out, "My God, you've got big ones!" referring to my breasts, and then he lunges at me.
What did you do?
Well, I was terrified and I just wanted him to go away, so I decided to fire a warning shot. I was only meant to scare him.
How were you holding the rifle?
In an upright position, because it was only supposed to be a warning shot. You've always got to be sure that you're not aiming at anyone, and while I enjoy target shooting, I would never shoot at a person. That would be criminal.
Your Honour, I call for Exhibit B to be handed to the witness, please. Can you show me exactly how you were holding the rifle that night?
Like this.
Thank you, Miss Martin. So, what did you intend when you fired that shot?
Well, as I said, I just wanted to scare him off. I didn't want to hurt him. If I did, I wouldn't have got him in the leg. I'm a good marksman, and in training I always aim for vital organs. Never miss.
Thank you, Miss Martin. No further questions, Your Honour.
Miss Martin, you mentioned target shooting. I take it you are interested in guns, aren't you?
Oh, I love guns.
And you know how to handle them.
Oh, of course, I can handle any gun.
And the first thing you did when you heard those noises was grab a gun. Seems rather strange to me.
Oh. Well, I'm not about to take a lecture in normality from a grown man in a white wig.
Ms. Martin?
Oh, with some exceptions, obviously.
I must object to my friend's questioning, Your Honour.
Sustained. Counsel, we are not interested in what you think is or isn't strange.
Why didn't you call the police, Miss Martin?
Because the nearest station's 45 minutes away. There's a fair chance Lord Lucan would get there before they did.
You said you turned the porch light on?
Yes?
That means you were standing in a well-lit area, doesn't it?
No. If I was standing in a well-lit area, I wouldn't have needed to turn the porch light on.
How far away from you was the victim standing before you shot him?
Before I shot him, he wasn't a victim.
Earth to witness stand. How far from you was Mr. Nielsen standing when you shot him?
Well, he wasn't standing. He was lying on his back, holding his leg, moaning, "You shot me as indeed you were quite entitled to, within the meaning of the Crimes Act as amended," or something like that.
You're on your own.
Oh, don't be like that. 3 metres.
How can you be sure?
Oh, is it my garden or is it your garden? Besides, I'm a very good judge of distance because of my shooting training.
He was standing by some bushes, wasn't he?
Yes?
Is that area well lit?
No, it's not.
So a man is standing 3 metres away in a poorly lit spot, and you can see from your position in a well-lit area that he is exposing himself and lunging towards you.
Well, I could see because the street lights and the porch light meant that the area where Mr. Nielsen was standing wasn't in total darkness. And what's more, when he lunged towards me, he came to the bottom steps of the porch.
How would you hold your rifle to shoot someone? To shoot me, for example?
Oh, there's an idea.
Your Honour...
Oh, settle down. Coronary artery disease will get you before I get a chance. You'd aim your gun at the target, of course.
You said you held your rifle in an upright position.
Yes.
How is it possible, then, to shoot someone in the leg if you were, as you claim, holding the rifle upright?
What are you suggesting? This is an outrage. Who's on trial here anyway?
Hang on. I'll check the papers. Let me see. Who's on trial here? Who's on trial? Ah! That's right, you are.
Oh, good.
I repeat, how is it possible to shoot someone in the leg if you are holding your rifle upright?
That's a very excellent question. I don't know what happened, but I was being very careful.
It is possible that at the time you fired the rifle, you weren't holding the rifle upright, isn't it?
I don't know.
What do you think of people who expose themselves?
That they should be lined up against a wall or a dimly lit garden and shot.
You don't think they belong in society, do you?
No fooling you.
And what did you think Mr. Nielsen was doing in your front garden on the 19th of January 1998?
Making a very bad decision.
So let me see if I understand. You hear noises, so you then get your rifle and you confront a stranger without calling the police. You are an experienced shooter, yet you shoot the man in the leg and you expect the court to believe that you didn't mean to shoot him?
Oh, thanks for reminding me. I didn't mean to shoot him and I took every precaution to avoid injuring him.
Just before I finish, you have been convicted of assault, haven't you?
Objection, Your Honour. Section 399, sub 5 of the Crimes Act.
Counsel, what do you think of that?
Well, Your Honour, the defendant has previously given evidence of her good character. Consequently, the prosecution is entitled under Section 399, sub 5b of the Crimes Act to question her on her unbelievably extensive list of prior convictions.
I have a discretion under subsection 6 of Section 399. Questions of the defendant regarding prior convictions should only be permitted in exceptional cases. Objection sustained. That will be all, Ms. Martin. You may step down. Counsel, you may close your case.
Thank you, Your Honour. That the accused shot Mr. Nielsen is not in dispute. We have proved she did so intentionally or recklessly. Hearing a noise, she grabbed a rifle. She did not call the police because she had her rifle in her hand and mayhem in her mind. She shot Mr. Nielsen unlawfully. Yibbida yibbida, bang, that is all.
Your Honour, the defendant is a young woman who lives on her own. She knew of a rapist being in the area. Woken from her sleep, she is confronted by a man who, given the hour and his actions, presents a threat to her safety. She fired a warning shot, which unfortunately hit him in the leg. She did so neither recklessly nor intentionally. We are the defence. We don't have to prove a thing. The prosecution does. And they haven't done so today.
Well, what did you think of that? Did you pick any mistakes? Let me take you through this trial, but just before I do that, let me briefly explain what cross-examination is. Cross-examination is the questioning of an opponent's witness after that witness has been examined in chief. Now, a good cross-examination secures qualifications, retractions, or additions to or subtractions from the evidence that that witness has given in chief. It obtains evidence which is favourable to the cross-examiner's client, and or it discredits the witness who's under cross-examination as a truthful and reliable narrator. A good example of this was when the defence counsel was questioning Mr. Nielsen on his drunkenness. In cross-examination, as in examination in chief, all the questions must be relevant to the issues in the case. But questions in cross-examination may also be directed to the credit of the witness. For instance, it was relevant to tender evidence of Mr. Nielsen's presence at the computer seminar earlier in the evening, because that was part of the chronology of the events. However, it would have been irrelevant to go into details of the seminar or the types of computers which he sold. Unlike examination in chief, leading questions are permitted in cross-examination. In fact, a leading question such as, you focused on her curves, didn't you, is an extremely useful strategy because it's shortened to the point, it directs the witness to give the answer you're looking for, and it means you already know the answer. It's very dangerous to ask questions to which you don't know the answer. If the cross-examiner intends to call another witness or to lead other evidence to contradict the witness on the stand, the cross-examined witness must be given an opportunity to explain the foreshadowed contradiction if he or she can do so. This is known as the rule in Brown and Dunn, a case decided in 1894, and it was satisfied in this case when the defence counsel asked Mr. Nielsen whether he was wearing a pair of black underpants on his head, whether he said, "My God, you've got big ones," and whether he lunged at Miss Martin. Sometimes a point can't be made by asking what appears to be the one question. For example, it would have made little or no impact if the prosecutor had simply asked, "So the man is standing 3 metres away in a poorly lit spot and you can see from your position in a well-lit area that he's exposing himself and lunging towards you." The most was made of the evidence by first establishing that Miss Martin was standing in a well-lit area and it was dimly lit where Mr. Nielsen was standing. This method is preferred because the witness's powers of observation are emphasised and hence her credibility and reliability. The advocate, you must remember, has the power to ask devastating questions to reveal that a witness is biased or is clearly a manipulator of the truth. However, the judge may prohibit questions which are offensive or scandalous. The cross-examiner must accept the witness's answers to questions about his or her credit. It's only possible to contradict those answers by calling other witnesses where the cross-examined witness does not admit that he or she is biased, where the witness has made an inconsistent statement beforehand, where a general reputation for lying isn't admitted, and if the witness denies that she or he is suffering from a medical condition affecting the reliability of evidence. For the purposes of this competition, each advocate is required to call one witness in support of his or her case. The advocate's examination of this witness is called her or his examination in chief. The most important points to remember in examination in chief are to allow the witness to tell the story with as little interruption and guidance as possible and to avoid leading questions, that is, questions which clearly suggest an answer. For example, it would not be permissible for the prosecution to ask Mr. Nielsen, "You were zipping up your pants when you turned around and saw the defendant, weren't you?" The advocate must be able to control her or his witness at all times. This was not achieved by the prosecution in this trial. Finally, let me talk briefly about courtroom etiquette. There are several formalities which need to be remembered. Always stand when the judge enters. Counsel must stand when addressing or being addressed by the judge, and address the judge as Your Honour. In acknowledging rulings or comments made by the judge, counsel should respond with "Yes, Your Honour," or "If the court pleases." Responses such as "sure" or "okay" are inappropriate. Don't comment on answers given by witnesses. Avoid American terminology. Finally, while Hollywood courtroom dramas may be spellbinding for some, it is strongly advised that you forget everything you learned about advocacy from LA law. It is always far more persuasive to lead evidence calmly than to pound the table and shout, "Objection, Your Honour, counsel is badgering the witness." And a last word. Good luck in this important competition.